Network, and her talk will be called Patents and Copyright and Trademarks, Oh Why?
So hi, thanks everyone for coming to listen a little bit about the law and how it intersects with software. So yes, my name's Andrea Casillas. I'm the director of the Linux Defenders with the Open Invention Network. Disclaimer, I am a lawyer, but this is not any kind of legal advice. And what I'm here to give is more or less an overview of intellectual property law and how it affects the software that you all are working on. Beyond the law and before the law, I was a biochemist, so I have no idea how I'm here. No, I actually discovered open source and free software through working with the Patent Reform Project in the US. And I actually collaborated with some professors at QUT and then the Australian Patent Office. So Australia has a very near and dear to my heart. So what am I going to cover? I'm going to talk about software licensing. But first I'm going to talk a bit about what software licensing is not and how it is affected by the laws that we have to work with. So there is a constellation of legal constructs that you sometimes hear referred to as intellectual property law. And because it's given this umbrella term, it can be a little confusing because you're given or you're made to think that all of these forms of law have equal bearing. And they don't, and they affect different aspects of the law. So the terms can become a little bit tricky, which is why I wanted to get into them a bit. So as I introduce these, just remember, it's a very rough overview. Every law has its nuances, and similarly, every country has its own nuances with the separate laws. But generally, trademarks are for logos, names, and symbols. Copyright covers written word, art, and music. And patents are intended for inventions. So these three concepts were originally designed to provide ownership rights for tangible creations. None of these were created with software in mind. It's obvious, but we have to remember that because these three have evolved just in themselves pertaining to tangible creations, and then throw software in it, and it becomes a little bit more confusing. So we'll look at what each of these cover, and then the intent behind each of these, and then how we can use them as creators or, like me, enthusiasts. So let's get started. Trademark, like I said, generally for names, logos, and symbols. So this is from the Roman Empire. This is a Roman brick mark. And of course, this is before trademark law existed. But what Romans did was the brickmaker would have a stamp and stamp this on. So there was an indicator as to who made this brick. And from that, we could decide whether or not the brickmaker could produce quality work. So quality meant if the building stood up and stayed up, it was good, and we knew who created it. If the building crashed, then they were not good, and we weren't going to ask them to create it again. So it served to form that kind of indicator. And it helped answer the questions, is this from who I think it's from? Is it safe? And will it be good? So we start to get in to other forms, or to trademark. And trademarks start to begin to distinguish goods and help kind of indicate what the quality of the product was, or it just helped with maintaining, it helped the consumers know that they could trust the type of product that the company was bringing. So this is Bass beer. And the triangle, the red triangle, was the first trademark. So Bass, then, these companies would get the trademark. And they only really use it to enforce if somebody else or another company used their name or logo to kind of counterfeit. So this was more of an enforcement mechanism. So you see the red triangle. Well, does this mean that BAS has all red triangles? Of course not. So this is another red triangle, but it's associated with gas. So we aren't confused between the BAS red triangle and the gas red triangle because the intent of the mark matters. We know that it's pertaining to one type of consumer area, and we're not confused. So we know exactly what the quality is, and we know the product and who's making it. So here is the Python trademark. And this can be found on the foundation page. Similarly with any kind of trademarks in any other languages, there's a page indicating exactly what the trademark can be used for and what it cannot be used for. And this is to keep the quality. Everyone knows that this software is good, and we want to maintain that. So we don't want to see any kind of deceptive uses. So altering the logo is a no-go. Changing the name and then just even using the same logo is not good. And it actually, on the page, tells you don't do that. And so the idea is to prevent against this deception. And restrict, the usage unless it pertains to the actual intent of the goods. So this is just a list of what's good, which usually is good, and what is highly questionable. So using the trademark to refer to the holder is usually good. Same as using the trademark to talk about the holder, or using the trademark to say that you are using something. Things that are questionable. Using the trademark to impersonate the holder. Using your own version of the trademark in a similar context, or using the trademark to imply endorsement that you don't have. So we don't want you to be deceptive, and that's more or less the takeaway, is that you don't want to be misleading with another entity's trademark. And if there's any kind of question, then look at the pages or ask the foundation. And there are various other things that are that can be trademarked. Color is one example, so is sound. There's various different aspects. So up next is copyright. Copyright was originally just for books. It's an expression of an idea, and you basically think of it as the content. So before the printing press, copyright law did not exist. This is a picture of all the scribes copying books. There were only so many scribes, and the issues pertaining to preventing others from copying your books just weren't around pre-printing press. Well, then came the printing press, and everybody kind of freaked out because books were going to go to the masses, and everything would be copied. So from that, we start to see copyright law begin to develop. And you see it with the duration. So initially, it was a 2-year duration, and it kind of grew into a 14-year duration. And then if the author was still alive, you could extend it for another 14 years. And then with the Berne Convention, the duration of copyright became lifetime of the author plus 50 years. And now it's lifetime of the author plus 70 years. Similarly, what would be considered copyrightable has expanded. So began literary works, art, and music. And now we see it, 1971, software is now copyrightable. So all software licenses rest on copyright law. And what I mean by this is default copyright is legally speaking, no one can use any of your code without your express permission. So what software law does, or software license does, is that it rests on top of that and says, hey, you can use my code if you work within these parameters. And so with each license, you have some kind of responsibilities, rules, just basic parameters that are set out for you, and you can use with permission. So then it becomes really important to pick the correct license. And it depends on what more or less your code is and what you want to do with it. But this is just, again, a general sense or a general list of what you should be doing. Check your upstream, check your boss. And then you see this kind of spectrum of different kinds of licenses that are available to use depending on what you want your code to do. So you see the copyleft licenses that are more pertaining to the GPL, or that's just one of the examples. And you're saying that modified versions of your code and all code in the resulting derivative works are free software. So it's a share-alike kind of license. And then you kind of move beyond that, and so you get into a weaker copyleft, and then more permissive licenses. So the code can be incorporated into free or proprietary projects. And they may include an attribution clause and these kinds of instances, which you see with Apache or Python. And then, if you're really feeling creative, you can create a new license, although this isn't recommended because it's really time-consuming and kind of a terrible process by all accounts, unless you're an expert and you want to dedicate time to create something new. So this intersection we see in intellectual property between copyrights and patents pertaining to software becomes really contentious. And I think that everyone has heard of all the litigation that happens and occurs from software. So let's just dive into it. So patents. Patents pertain to functionality. So think of it as an answer to, but what does it do? So the point of patents, and it's kind of important to remember this, is to promote innovation. So you have the inventor, and he or she applies for a patent, and if it's awarded, then they are awarded a monopoly for a set duration. Generally, it's 20 years. But they're awarded this monopoly to prevent others, so you actively have to exclude others from making, using, selling, offering to sell, just a list of things. You have to prevent others from using your patent. But what happens, and in exchange of this, is that you share what you did with the larger public. And then after your duration is up, the public is able to use your invention and create from it. And so the idea is that, okay, you get this monopoly, but in exchange, we promote innovation for society as a whole. So what is patentable? Which is kind of a loaded question. It's probably easier to answer what is not patentable. So not patentable. Abstract theories, ideas, and concepts, okay? Natural laws or processes. That's good. Algorithms on their own. So you cannot just give your code to the patent examiner and it'll be patented. It is your translation of what that code does that's patentable. Mathematical equations. Inventions that are already known or used. We don't want to give a monopoly to somebody that just picks something out that people were already using, in theory, right? Obvious fixes. So this is the same as the inventive step, but in the US we call it non-obviousness. And basically, if, like, say you have something like a bicycle, if we don't want to give you a patent on something that if you just move the pedals up an inch, that doesn't really, unless you can show that that has drastically improved the state of bicycles, we don't want to award a patent for that. things that are out of scope, so like a time machine. Unless you can make it, and again, that'd be cool. And illegal activities. Oops. So usually this pertains to tax fraud. People get pretty crafty. We don't want to give a patent for that. So these patents, of course, have also evolved from just answering and giving the tangible product or tangible invention that answers how I fix the problem. So now with software patents, you have, this is how I fix the problem on a computer. So how do you know if something's patented? Well, that's really, really hard to answer because most patent databases are huge, and they're very hard to search. I search them every week. And they're hard to read as well. I don't know if anyone has ever read a patent. Anyone? Is it fun reading? No. So the guts of the patent are the claims. And those are painful to read. And we'll get into that a little bit later. And most lawyers are actually going to deter you from looking for patents if your work is something similarly related. In the US, we have something called willful ignorance. And so if you find something that's patented and you're like, hey, whatever, I'm still going to develop my stuff, you can get sued. And if they can show that you found this and you knew about it, then you get sued for 3 times the damages. So lawyers are kind of steer you away from that. So anyways, tons of patents. And there are, yes, lots of patents in the US. There are lots of software patents everywhere. And nearly all of them have claims written in the broadest possible language, especially in the most lucrative areas of software. And nearly all software areas have patents. Some of them just happen to be famously worse. So why are patents so hard to read? Why are they so hard to understand? It basically gets into functional claims. And so what are functional claims? They're a way for patent lawyers who want to get the broadest claim scope of the patent to just kind of describe the patent. So I'll give you an example using the pencil. So a functional description of a pencil would be a marking element. All right? Now, a structural, which kind of gives you more of a sense of what this thing does, would be a cylindrical piece of lead surrounded by encasing material. So patent lawyers use more functional kinds of claims because they're easier to write, because you don't have to explain how the invention works. You only have to explain what it accomplishes. So a software example would be a circuit configured to receive data. It's a functional claim. Or software configured to display an image. Okay? So there's a generalized portion, which is the circuit or the software, but it's not claiming the exact design of the structure. So that kind of leaves us to not really know what is being claimed. And so these are numbers from the US. But you can see that there is a drastic rise in software patents being granted. And yes, they're US numbers, but unless you can guarantee that your software will not reach the US at all, everyone can be affected by these US patents, particularly with all the harmonization efforts and everything taking place amongst patent offices. So along with that rise in software patents, we also have a rise in software patent lawsuits. So this is just a chart pertaining to non-practicing entities. Non-practicing entities are also called patent assertion entities, or trolls, is what's the not so nice way to describe them. And so we see this rise in troll litigation. And even though we see the big the phone wars and all this going on, the troll litigation is pretty problematic because they're no longer going for the big companies. If you're making any kind of money, they're targeting everyone. So trolls, and just as a background, because I kind of skipped it, they don't write the software, or they don't write the patents. They don't produce the product, but they purchase the patents, and their revenue is either, is threatening others of litigation to either derive licensing fees or they'll go to court based on the patents that they have. But I don't want you to think that all litigation pertains to trolls. So what happens in litigation? I mean, it's pretty basic. Either the plaintiff asks for some kind of injunction or money, or both. And so who gets sued? Well, not all suits are the same. So you can have a practicing entity, a company, versus another company. And I mean, this is basically if you have competitors, is the answer of whether or not you could get sued. And so some of these suits are based on a situation where one company sees another company moving into their space. Okay. And some of these lawsuits are when one company sees another company moving to space that they'd wish they had gotten into. So that's kind of more of an anti-competitive suit. And so we do see the problem, the troll suits versus the company. And there have been studies that are showing that 40% of startups that are small to mid-size have encountered some kind of lawsuit with a troll. So basically, the answer is that we don't want to be that little guy in the background. So what can you do? So you can join a non-aggression community. And the company that I'm associated with, Open Invention Network, is one of these companies, but there are other companies that exist that do the same. It includes access to a defensive patent pool, so that in the event that you are sued, you have licensed all this other arsenal of patents to kind of protect you. And so that's one option. And keep in mind that there's a multi-pronged approach when addressing these issues. You can choose a license, back when you're trying to pick a license, that has a patent clause. So if somebody sues that also is licensed to the same, has the same license, then right away that they're no longer licensed because they are the aggressor. And then you can also defensively publish. And this is actually the project that I run. It's called Linux Defenders, and what we're trying to do is create prior art and reach out to all the open source communities to get in front of the examiner exactly what open source is doing. So the state that most patent examiners experience is that they reference a lot of prior art, and prior art is evidence, in any kind of office action or during the patent application process. They reference a lot of patent literature. So people who patent are getting a voice in the patent office. People who don't patent are not getting a voice. So my project is essentially creating a database of open source projects or technology so that they have this prior art in front of them when they're reviewing a patent application. And if you have questions on that, we can talk about that later. But here's a quick recap. This is not legal advice. If you need a lawyer, please, please, please get one. Trademark. Don't pretend to be someone else. Copyright. Choose a license that matches your goals for your code. And patents. The best offense is a defense. And are there any questions?